Hello, everybody, and welcome to another installment of our IPRIA IP Australia speaker series. This one in the webinar form, which I really enjoy because it does allow so many of the people who aren't able to attend our inner city in-person events to come along. But do keep an eye out for those as well, because they're also very fun. You can sign up for the IPRIA mailing list if you'd like to do so. I'll send a link for that if you're not already on it. I am coming to you from the unceded lands of the Wurundjeri people of the Kulin Nations. And I'd like to pay my respects not only to elders past and present and those who are emerging, but to all people who are working to restore lost language and knowledge and culture. I'm going to hand over now to Ben Mitra-Khan, just with thanks to IP Australia for its generous support of this series, which is intended to bring you provocative conversations that are really at the cutting edge and really relevant to the intellectual property and data issues of our time. Ben, over to you.
Thank you, Rebecca. And I'll join in acknowledging people of the coalition where I'm also coming to you from, and pay my respects to elders past and present and those emerging. We've got a really exciting session for you today. We have a presentation from Alphonse Palanga-Carrera, who's going to talk about the latest insights on computer implemented inventions, and he'll do that for a couple of minutes. I'll introduce him in a second. And then we've got a conversation between Professor Mark Lemley and Professor Beth Webster, which I will try to direct, but probably not say much in. And I'll introduce them in a second too. And then we'll have the opportunity for Q&A. There'll be an option in the chat function and the Q&A function. You can put your questions in, and we'll do some of that at the end. We also happen to have IP Australia sponsoring this, so we happen to be blessed that we have people like Dr. Michael Falk in the wings, the chief economist there, and Deputy Commissioner of Patents, Nathan Matheson, in the sidelines, who knows more about computer implemented inventions than anyone I know, at least, in Australia, and has been in that space for a long time. So there's a lot of interesting firepower. But let me do a quick introduction to each of the speakers. They are on the video. And the way that I've learned you do these things, when you talk about AI and computer implemented inventions, you ask ChatGPT to write the introduction for you. And that's a much simpler way of dealing with it. And you get interesting questions. The first one I want to introduce to you is Professor Mark Lemley. Now, ChatGPT describes him as a luminary in the field of intellectual property law and technology, and that's not unfair. He's got a fantastic track record, fascinating insights on the sides of his excellent legal work. He claims to be an economist too. I think he is an economist too. And he's coming to us live from California. And that's going to be really exciting. We have Professor Beth Webster, who is, again, ChatGPT, a leading economist renowned for expertise in innovation, technology, and productivity. Beth has been a mainstay of the innovation and industry analysis and IP community in Australia for decades. And has great insights into what we can do, what we can think, and is always reminding policymakers that you have to grow the pie before you can split it up. And I think that'll be fascinating to hear from her. But first, we're going to hear from Associate Professor Alphonse Palanga-Carrera, who both ChatGPT and I think is an esteemed economist, but he's particularly renowned for his expertise in applied microeconomics, that's industrial organization, innovation policy. He does lots of interesting things with microdata and understanding how IP fits in the economy, what the economy can do with IP, and how we see that fitting together. He's been working on a project with IP Australia on computer implemented inventions and has the latest trends, views, and data that's coming out of that. So I might hand over to Alphonse.
Thank you, Ben, for giving the time, and thank you to Rebecca, and thank you for IP Australia for commissioning this project. So this is a shared project with Michael Falk, Chief Economist of IP Australia, and a colleague from our Center for Transmedia Innovations, Beth Webster, Sarah Hegarty, and Trevor Coleman. So I'm going to give 5 minutes presentations of this, the project currently, the status of the current project, and the very preliminary findings. So the objective of the project is basically trying to have impact assessments of two landmark cases in 2014, which I assume everybody is familiar. These are the research affiliates case in Australia and the Alice Corp in the US. And two research questions are identified that we aim to answer by the end of this project. The first one is how these two landmark cases that might have implication in terms of the assessment of CII, or computer implemented inventions, as patentable subject matters. How does it affect patent applicants' behavior, basically, which is going to be reflected by changes in CII patent application filing trend, and then how is this affect the patent application examination behavior within the patent offices, and which will be reflected by a change in the patent application outcome comparing before and after these landmark cases. So in summary, these are two main primary findings. They are indicative, not we shouldn't make any conclusive statement based on these findings yet. We are still working, trying to unpack these early findings. So the first one, it appears that CII patent application filings still continue to increase, especially in Australia and the US, but there does appear some flattening in the rate of increase in patent filing in the European Patent Office. The second finding is that it appears that there is lower grant probabilities of CI patent applications, especially in Australia, and maybe to a lesser extent in the European Patent Office, but not so in the US, which is probably not surprising if you're familiar with how there is the debate between the Patent Office and the Circuit Court in the US, that the decisions of Supreme Court with regards to Alice is not going to be taken or interpreted by the Patent Office as restrictions on patentability of CII as a subject matters. Basically, what we did first is trying to identify all CII patent applications. And we adopted an approach that is done by a European report in 2015 by the Fraunhofer Institute, that they consider it as a relatively providing a lower bound of CII by selecting only highly precise keywords with more than 90% precision in identifying patents that are considered as CII patents. And then based on that keyword and IPC filterings, we identify CII patent application sets within the IP Australia, the USPTO, and the European Patent Office. And what we bring into this literature is we actually add another layer where IP Australia provided us with a set of CII patents filed within IP Australia that have been seen a manner of manufacture objections being raised. And so what we do here, we try to identify all CII patent applications within the three patent jurisdictions I mentioned earlier, which are considered to be very similar or highly similar to this set of Australian CII patent application with manner of manufacture objections. So this create a set of CII patents and a set of CII patents which are probably borderline more in terms of patentabilities, because they might have problem in terms of manner of manufacturers or within IP Australia and similarly within the other patent offices. So this is a summary of the keyword and IPC filtering that is implemented by the European Patent Office report on an earlier study by C and Miyazaki, who look at CI patent application only within automotive technologies. And what we found is that, first of all, having defined those different patent applications, so in IP Australia, there is an increasing trend of CI patent applications over time, where we, in the study, we look at 2001 to 2020. And if we compute the share of CI patent application as percentage of total applications, then this increasing trend is even clearer. And now it's reached close to 40% of all patent applications within IP Australia can be considered as CI patent applications. Now, some of us might think that the keyword approach and the filter, the IPC filtering approach, result in a too broad criteria that identify many other things that's probably pure hardware inventions. But I just want to remind you again that the European patent report that we use, the method, they think this is actually a very conservative and providing just the lower bound of the true CI patent applications. So when we compare it with the US Patent Office and European Patent Office trend, and because a different scale here, the IP Australia count looks a bit flat, but we already seen earlier that there's an increase, and we can see in the US is an increase, and in European Patent Office there is an increase, and this increase can be seen clearer when we compute the same share of CI patent application in all total patent application. So in the US, it has already exceeded more than half of all patent applications would be classified as CI patent applications. Now, if we identify out of the CI patent application which are very similar to the set of Australian CI patent application with manner of manufacture objections, then we can see that in the US, a high percentage of that, up to 70% of those CI patents would probably be subjected to a similar manner of manufacture objection if it were to be examined in IP Australia. So the proportion is a bit lower in the other two offices, but they're still quite high. More than half of them are considered as Australian CI patent applications with manner of manufacture objections. So and also it increases, and this is one part of the conclusions I summarized earlier, that the increase seems to be the continuing increase seems to be true for IP Australia and USPTO, but at the European Patent Office, it's flattened a bit. And at the end, there's a lot of data truncation. That's why we see a lot of these huge fluctuations. Now, in terms of outcomes, we expect that CI patent applications that are likely or they are similar to Australian patent application which receives manner of manufacture objections to have lower grant rate. So for IP Australia, it's clear that those with manner of manufacture objections have a slightly lower grant rate compared to the other CII patent applications which are not similar to the manner of manufacture objections CII patent applications. or compared to non-CIA patent applications. And however, this expected relationship between outcome and the classification of the patent applications are not found with respect to U.S. Patent Office, where in fact at the USPTO, the CIA patent applications which are likely to have a manner of manufacture objection if it were to be submitted or examined by IP Australia examiners, they actually have a higher grant rate. And at the EPO, the CIA patent applications have slightly lower grant rates compared to non-CII, and the one which are similar to manner of manufacture objection also have a slightly lower grant rate. Lastly, we look at we compare between the period before 2014 and after 2014, and looking at whether those two landmark cases for IP Australia, especially the High Court case with research affiliates, actually have an impact on patent examination outcome, and this chart seems to indicate that there is a reductions in the probability of a grant for patent applications, especially for patent applications which are likely to have a manner of manufacture objections. We don't see the same effect for CII patent which are not tagged as likely to have a manner of manufacture objections. Now, 2014 doesn't seem to make a difference at the USPTO, and in fact, the grant rate is higher after 2014 than before 2014. Against the legal literature that look at US cases have good explanations for this, including some of the paper from Professor Mark Limley. And in European case, there seems to be a slight reductions in the grant rate comparing 2014 and before 2014 and after 2014. So those are really very preliminary results, and we haven't. We are planning to do a more robust analysis. First of all, we need to compare apple to apple if we are talking about the three different jurisdictions. And usually in the literature, what that means is we need to look at the the patent application outcomes of triplet patents. That is the same set of inventions which are simultaneously filed at the three patent offices. And we have run some different analysis more formally instead of visually in order to try to understand the role of invention characteristic and patent application characteristic. And definitely we are looking for other suggestions. That's pretty much a summary of the result of our study right now. Thank you very much.
Thanks for that summary of the sort of current state of where we are in Australia in terms of this field and applications. At this point, I'll bring in our two panelists, and I'll introduce them a bit more calmly this time. First of all, we've got Professor Mark Lemley joining us from California. Good evening.
Hello.
Mark's the William Newcomb Professor of Law at Stanford Law School and Director of the Stanford Law Program, Law Science Technology. He also, those of you will be familiar, he also co-founded Lex Machina and does a range of work there, both for the courts and for academia. So great joy to have you with us. We're hoping to hear about the US perspectives. And we have Professor Beth Webster from Swinburne University, who is the director of the Center for Transformative Innovation at Swinburne. And she's also, I think, one of the leading economic academics, if not the leading economics on IP in Australia, and has led IPRIA before and continues to deliver fascinating work, and obviously worked with Alphonse and made him put the slides on, which was fantastic. Thank you, Beth. I might, just bouncing off what Alphonse has shown us, I might go to Beth first and come to you, Mark, if that sounds all right. But feel free to interrupt each other. I mean, politely. So Beth, so computer implemented inventions are clearly not going away. In fact, they seem to be everywhere and everyone doing them. Is that a good thing for the economy?
Hark back to my favourite British philosopher, 20th century British philosopher, Alfred Whitehead, who said, economies advance by enabling the economy to make decisions without any manual interference, some sort of automatic process. And he was talking back in the 1920s about the market system being an incentive system to drive the economy. And I think now with sensors and chips, which is basically the sort of basis of a lot of these CII patent inventions, that's basically what's happening here. So this is really, I think, a fantastic thing in many respects. Obviously, it's got some a downside as well. But obviously, I think it's going to lead to free up a lot of people from doing routine, mundane work and enable them to do other sorts of more interesting things. So yes, I think it's on balance a good thing.
That sounds very reasonable. Mark, what's the view from the US on this? I mean, it looks like the US is swimming in CII applications.
Oh, absolutely. Yeah, no, and it's right. The numbers are truly astonishing. And so I think that sort of raises an interesting question, and my view, I think, may be a little bit different than Beth's. Right, so it's absolutely right that sort of innovation in the IT space is extraordinarily important. It does wonders for us. And the thing that I think is more challenging to demonstrate is that there's a positive relationship between the granting of, in our case, millions of extant patents on computer inventions and innovation in that space. Now, obviously, there is obviously a sort of positive relationship in the sense that both of them have increased. The question is there a causal relationship, and if so, which way it runs? And so here, I think the challenges we've seen in the United States, I think, have come from the fact that, in part because of the relatively slow nature of the patent system and the relatively fast nature of software innovation, and in part because of the just enormous number. I think the estimate a decade ago was that a fully loaded smartphone might implicate 250,000 patents in the United States, right? And now that number, I'm sure, is much greater. Right. And in part because of the sort of uncertainty is the sort of the scope and validity of these patents. The reality of the situation, I think, is that the people who are doing the innovating are mostly not doing the innovating on the basis that well, I'll have a patent and so I'll be protected. They're just going out and innovating. And then 5, 10, 15 years down the line, a bunch of people who got patents say, hey, boy, there's something I can read this on that looks pretty valuable. And so the vast majority of the litigation we've seen in the United States around software patents is not innovators suing copyists. It's patent trolls or those who've kind of bought up patents suing the companies that are actually been successful.
And so we don't see much of that in an Australian context, Beth, I'm assuming here.
No, we have looked in the past at whether, because there's a lot of discussion in America and Europe about patent trolls and people suing just for the purposes of extorting money, not for innovating per se. We did do a bit of a look at this in Australia some years ago. We didn't find much evidence for that. And then basically, possibly we're saying the big players in this field are not playing in Australia, they're playing elsewhere. But it does have obviously implications for Australia. But and 90%, as you know, Ben, 90% of our patent applications are from overseas. So that will have knock-on effects if something is going on in America or Europe.
Yeah, and so that fact, right, might suggest that that the problem we have in the United States maybe isn't a problem with the patenting of software per se. It's a problem with our litigation system, right, or other structural aspects of the system, whether it's the jury trial right or the sort of large damages awards that we have traditionally been granting. So it's hard to know exactly. I mean, I do think those are systemic problems in the United States, but it is worth noting, right, that in the United States, they mostly manifest in the software and the telecommunications industries, right? We don't see similar problems to nearly the same extent in other industries. And so if you could get rid of that problem, right, I think there are perfectly good economic arguments that say, right, the sort of patents can be valuable, right, not in the traditional sense that we think of patents as being valuable, which is I will exclude my competitors from the market, but for a variety of other sort of economic benefits. I think they're often useful, for instance, for startups to persuade venture capitalists to invest in them. VCs look at them as a kind of signal that you have a sense of what your market is, what how you're defining yourself relative to your competitors. I think they serve as a kind of focal point for licensing or business decisions that are often really more about know-how than buying the exclusivity, but the patent is something that we can sort of focus on and say, yeah, here's a thing that's part of the transaction.
And so I guess that goes to that question of the economic logic of having a CII patent and patent system for them. And I guess this is the legal side of it, and the economic side often get a bit muddled, at least in my head. And I thought that was a good reflection on the legal side. And I wonder, on the economic side, do you see an ongoing role for CII patents in the sense that, are they incentivizing innovation in the kind of innovation we want to incentivize? And are they facilitating tech transfer? Or are they becoming more of a pivot point around venture capital or licensing stories? So licensing is tech transfer, I guess.
I don't know if you can separate them, can you? Really, they're sort of people. We understand when they take out a patent have multiple motives. It's not just for potentially developing or licensing. They also talk about freedom to operate. They talk about advertising, signaling that they are the place or the best technology on the technology frontier. So people do patent for multiple motives bound up in one up together. I think, and always there's going to be extremes where people use it for, the troll reason and use it for extortion. But the surveys we have done, and this is not just on CII patents, but on patents generally, shows that the core are still used to develop, maybe to license. It depends on the industry. Some industries do a lot of licensing and others don't, but they usually are used because there's a genuine interest in going forward. Now, I think Mark's right. At the extreme, you've got those the area where you've got a lot of litigation going, but that's not necessarily the whole industry. And especially sensors and chips are very much part of Industry 4.0. It's very much back to the basic manufacturing industry, which started the whole patent thing anyway. So I think that's maybe if I talk those figures on the percentage of patents that are CII is astounding, really, and the growth rate's really amazing. And it's really putting the focus back, I think, on manufacturing.
Yeah, I think that's really interesting, and to me, I think one of the challenges, and I think here it might differ a little bit sort of between the hardware side and the software side, as Beth suggests, right? One of the challenges that we face, and I guess I don't have the same sense of sort of what the process looks like in Australia, right? But we've gotten pendency down a little bit in the United States, but it's probably still on the order of 3.5 years between the time you file your application and the time you get your patent. And I think in a lot of software areas, that's an eternity. Right. So, we're just now starting to see the patents issue from the pre-generative AI AI world, right? When AI was going to be about self-driving cars and all of that, right? Nothing about generative AI, I think, has yet made it through the patent system. So I think one of the things that does is it means that a lot of the business transactions and a lot of the licensing end up taking place in these kind of fast-moving early stage industries on the basis of trade secrets, or maybe I have a patent application and I might get a patent, right, or kind of know-how analysis. And if there's a way to speed that process up, I think that might make it easier for people to know what rights they've got at an earlier time and to transact around them.
I mean, I totally agree that pendency problems are a real issue, but America is the fastest office in the world. So you can imagine Japan and Europe are very slow. Australia's not so fast either. I think it's because you go straight into examination once you file, whereas, a lot of offices don't require you to request examination for a few years, which I think is a real issue in this very, very fast moving area. So the challenge back to the patent offices, I think.
I'm going to stay out of the pendency debate. I'll let the Q&A go for that one. But I guess that sort of goes to the broader question, and someone has raised that as part of the question as well, is this question of, so where do we sit then in terms of US, fast, lots of CII patents, lots of them being granted, the decision in Alice, that seems to only spur more applications, frankly, and the same grant rate, really, because the world moved on, right? And then you got Australia, and then the European Union, perhaps, or European Patent Office, as it were. At the bottom of that, quite slow, very restrictive, but also grants a lot less of these. Is that a fair reflection?
I think that's probably right. I mean, to some extent, the European Patent Office is just kind of more, they appear to hold a higher standard than the US Patent Office, right? They grant fewer patents across all areas than the US does in percentage terms. But I think what's happening with Alice in the United States is really fascinating, right? So the Supreme Court, in a series of decisions kind of culminating in Alice in 2014, created a much more restrictive a patentable subject matter eligibility requirement, right? And also, frankly, a bit of a vague one. And so we've spent the last 10 years kind of working out the rough contours of what it looks like. And if I had to sort of define what those rough contours look like, what I would say is things that feel to the court like they have real technological implementation, technological change in the operation of the computer are going to survive Alice. They're going to be held to be patentable subject matter. Things that are either claimed into sort of purely functional terms, solve this problem in a computer, but I don't tell you how, or use a computer to do something else, sell pet food on the internet, right? Those are much less likely to be patentable subject matter. It's that's a rough kind of estimate of where the line is. It's really more of a standard than a rule. But the point you make, I think, is a fair one, right? A lot of people said, oh my gosh, right, this is going to cause most software patents to go away, and either, yay, that's a great thing, software patents are bad, or oh no, that's going to destroy software innovation. But the premise turned out to be wrong. It hasn't made software patents go away. I think one reason is people have been able to draft around the limitations of Alice to some extent. Another reason is that in 2019, the Patent Office adopted a very narrow reading of Alice, and so is willing to grant a lot of patent applications. That does not translate into the courts. And so it is still the case when those patents go to court, most of them are invalidated. The Federal Circuit's invalidation rate under Alice, when it gets a case, is something close to 90%. So we have this interesting situation where the patents are being granted when at least some of the questionable ones get litigated, they are often being invalidated. But the system nonetheless continues on. People continue to file them, they continue to get them. And maybe to go to our earlier discussion, right, they also continue to get the non-litigation business uses and value out of them, right? We use them as a basis for a licensing agreement, right, for a venture capital funding and so forth. And that might not be the sort of worst possible outcome.
Yeah, so I guess turn to you, Beth. I mean, last year we had an interesting High Court judgment, I think, in the space in Australia. which you might argue has led to more uncertainty, maybe less, I'm not sure. Is that uncertainty good? Is that space, because if it's taken the US 10 years to work through this, do you think that's a good thing for business and sort of work through, or where do you want to go with that?
Well, no one likes uncertainty, but uncertainty gives people who can see an opportunity that others can't a channel, a way to go. So in some, you need some, there's always going to be uncertainty in the economy. There's uncertainty in life, you can't get rid of it. But you don't want to create more uncertainty than is necessary. Which is why we're so always worried about the pending stuff and the proliferation of too many patents in a very crowded space. But that raises a really interesting point about if you've got so many more patents coming out using chips and sensors, or making chips and sensors faster and more flexible and more, doing more things, it raises the whole issue of international standards for a lot of the technology. Which then sometimes brings in standard essential patents. It brings in patent pools with the implication for anti-competitive behaviour, who's in, who's out. It brings in FRAND, all these issues about. It just blows them up. I know they're there, and the institutions are already there, but it's going to make it a much bigger space, I would imagine. I'm not an expert on standard setting organisations. I know there's a lot. There's private ones, there's government orientated ones, there's national ones, international ones. But I would have thought if sensors, you got to put sensors or chips into everything from toilets, I've heard, in hotels to tell whether they're blocked, right through to high-tech communication technology. I would have thought you're going to need, you don't want to have 1,000 different standards across the world, just in terms of repair, economies of scale and manufacture, installation, servicing, speaking to each other, that interconnectivity. I think they're going to become really, really important. And who controls those standards is going to become really important. Who's inside the tent? Is going to, in terms of countries or big corporations, and who's not. So it brings in more competition type rules about, and control too, which is your space, Ben. So I think in terms of the economy, that's where I would be looking. I think the trends are very strong. These High Court decisions, ILS decisions, might have had a bit of a influence at the margin. I mean, that's up for really Mark and people like Alphonse who are looking at it. But the overall dominant trend is very, very powerful.
I'll just say, as speaking to you from a country that doesn't have comprehensive data privacy protection, the concept of a sensor in my toilet seems a little
I think it's the case of, it seems very worrying, but it's probably been there a while already.
Well, they already measure sewerage, as you know, in local government areas to work out which suburbs are taking illegal drugs and which aren't, and where there's COVID. So you're already part of it, Mark, but not.
That's right. Well, and it's I mean, based on my experience with other sort of information, it's only a matter of time before it sort of translates directly to my Facebook ads. So.
I'm going to stay away from the whole Mark Zuckerberg thing. We're gonna forge forward on that. I guess the sort of the follow on from me then is this question around, where does that then lead us in terms of computer implementable inventions and software patents, and the from a policy perspective, where do we want to go with this? Standards are important, but the patent systems are different from country to country, world to world. What in your views, what is an optimal position to get to?
Yeah, I mean, so I guess I am a strong believer, sort of not just in CII, but sort of across the patent system as a whole. The system kind of has a life of its own. I did a paper several years ago called "The Surprising Resilience of the Patent System," right, which suggests that we've changed the law one direction or the other direction over the last 25 years quite dramatically in the United States, and it hasn't really moved the patent system itself much at all. I think the real question is sort of how much the patent system moves innovation, and I think it's a part, but I think it's one part of a much larger ecosystem, right? I don't, I think you could sort of make it much easier to get software patents. You could abolish software patents. Neither of those things is going to fundamentally change people's incentives to invest in these technologies. They view them as valuable. So to me, the real question is, right, are we helping or hurting at the margins, right? And so I think one of the things that it's important to do is to try through things like standard setting organization, FRAND rules, or restrictions on injunctive relief and that sort of thing, to make sure that the cumulative effect of all of these patents isn't to clog up the system and prevent or slow down the actual deployment of technology. And I think if we can do that, it probably matters less for innovation and for the system as a whole, kind of how many patents in the software world we have or how easy they are to get.
So just on a sort of a side issue too, what worries me about a lot of these new technologies, which, I love, and, we've all got an iPhone and what have you, because a lot of them are going to be connected into, the internet or some other connection system, the threat posed by cybersecurity, hackers and what have you is going to loom even larger than it currently is. The connectivity, it brings in data sharing sort of questions and privacy. So I know you got patents on the cybersecurity side too. So it's sort of patents fighting, patents solving the problems caused by more patents and inventions. In a sense, it's sort of, I don't know, not an arms race, but there's something going on. But I think we have to, I guess, as a society, think about strengthening the cybersecurity side too. We've already had a number of hacks in Australia. You might have had the same in America, Mark, of big organisations that have been. We had one of our telephone networks just completely shut down for a few days. We've had, health insurance data sets hacked, and it does really, that the possibility that someone can stop all the traffic lights or all the toilets flushing, or I don't know, is really real. And I think we need to be aware of that as well from an economic perspective.
I agree with that, right?
Yeah.
And I think there are a lot of values to connecting a lot of things, but I also think it turns out there's some values to making sure that not everything is always
connected. Yeah. Yeah.
I think that's fair. I guess we'll jump into the Q&A in a minute or two. I had sort of one thing that sort of bounced off from the Q&A conversation I want to test with you. And it's brought up, and I was thinking about this, and David Weber was on the chat, also thought about this, it seems. If the USPTO is running a system effectively of, well, let's grant it, and sure, there's a high likelihood it's going to get knocked out, but we'll leave it be. Is that a good model for innovation?
Yeah. So
or do you need a well-functioning court system for that? Like, are you predicating you must have a well-functioning court system here?
Well, or an assumption that we aren't going to use the court system, right? And so to me, right, like I think it works in the United States because the vast majority of the people getting those patents aren't then suing, right? And so we don't actually have to resolve whether they're valid or not yet, and that's right. And so one of the things we know from the experience with patent trolls is they often bring the lawsuits at the end of the patent life, right? It turns out, 18 years ago, I'm the one who invented voice over internet or two-factor authentication. We have a dozen different patent owners claiming that they invented two-factor authentication right now, right? But now that everyone's using it, right, now it's valuable and I'll bring it, right? So that's a worry. And so one of the things that worries me is, right, we're going to grant a bunch of patents and then have to invalidate them later in the courts, and it's an expensive process. One of the things that worries me about it is, Beth said earlier, right, sort of people don't like uncertainty. People might very much like to get their patent granted, but if they're coming in with the sort of mistaken assumption that the fact that they got this patent means it's likely to survive in court, that's not a great thing, right? If they know what they're getting, and and what they're getting is kind of a kind of lottery ticket, then okay. But I worry that a lot of the particularly less sophisticated inventors are not going to make that assumption.
Mm. And presumably, all this patent thickets, patent flooding, or whatever you want to call it, can have a chilling effect on invention of the less financially wealthy players in this field who will worry about infringement and all that sort of stuff. So that is a concern. That used to be a big thing about 15 years ago in the literature. It seems to have died out a bit. Maybe I'm not following the right literature, but you can see it coming back. Yeah.
I think it's definitely it's an issue. So I think one of the things that's happened is that we've got mechanisms that are designed to try to cope with it, right? I think FRAND and standard essential patents are designed to deal with that potential risk. But honestly, my sense is sort of in the software industry in the United States, mostly what people do is just kind of ignore the patents. They keep their head down. They don't read them, right? And so, only when they pop up and are sued do they, is there a problem? That doesn't strike me as the sort of ideal system, but it might be the right way to deal with a situation in which you might have 500,000 potential patents that somebody might assert cover your smartphone, but only 3,000 of those will ever be asserted against you.
What do you think, Mark, of the Japanese litigation system, where it's cheaper, quicker, and more prevalent, as opposed to America, where it's very expensive and drawn out?
But the backside of the Japanese system is if I want to sue in court, I've then got to go back and I do a deferred examination process, right? I actually think that makes a certain amount of sense, right? Because for the people who don't think they're ever going to be filing a lawsuit, right, who have business reasons or other reasons to get the patent, right, making it, giving you a quicker and clearer right is useful. If I think I actually do intend to sue, maybe then we do then want to sort of pay more attention to the question of should we be granting this patent. So I think something like that is a good idea. To some extent, the U.S. now, we've had for a dozen years this IPR system, which isn't quite that. I mean, the patent's already out there, but there's a way to go back and get the patent office to take a look at it that's much cheaper than litigation, and I think that's helped a lot.
Yeah, I think it's important to bear in mind that legal systems differ quite a lot, and the systems differ a lot. But it sounds like a lot of the comments in the Q&A is around this question around, what are trolls? Since we'll talk about trolls, my reading from the conversation so far is that trolling or non-patent assertion entities, whatever we'll call them, often comes with this point that, well, if you bought a bunch of lottery tickets, you shouldn't be surprised if someone tries to play the lottery against you. But if the system is a lot more certain, then the space for that activity is a lot narrower, and of course you should be able to enforce your patent, right? You've made a valuable contribution.
Yeah, I mean, I think the real, and right, sort of like one of the comments, right, talks about the sort of, hey, if I disclose this information, get it from me. One of the challenges, I think, is because of the delay, because of the speed of the industry, and because, frankly, in many cases, these patents they don't give you a lot of detail, they don't give you much information, right? It is
if you can find them.
If you can find them, right? And if you have the incentive to look, and if you can find them, right? But so for that combination of reasons, almost every lawsuit in the software industry filed in the United States is not filed against someone accused of copying the technology from the patent owner. They're filed against independent developers, right? They're filed against people who developed this technology on their own, and then somebody comes up and says, well, I developed it first, and I ultimately got a patent, and my patent can read on what you're now doing. So, to me, right, if what we think we're going on, where lots of people are out, even big companies are out there copying inventions from other people, that's bad. We want to stop it, and we want a legal system to prevent it. But the vast majority of the lawsuits we're seeing in the software industry in the United States, right, don't fit that mold, right? They're Apple developed something, and then 10 years later, somebody pops up and says, well, you've never heard of me or my patent, but I'm really the one who invented it. And even though you developed and implemented it, yeah, you owe me money.
I mean, that's interesting. I think the experience is somewhat different in Australia in terms of the litigation landscape. But also, obviously, cost awards help a lot in this context in Australia.
Yeah.
Makes
No, that's actually, yeah, that's right. I think one of the things, right, because we don't have fee shifting, right, we've got a whole industry of contingent fee plaintiffs, lawyers who, so it costs you nothing to file a lawsuit. We'll just take a share of your money if you win. And that's a, you know, that's a business model, I think, that's very hard to do in a country that sort of has fee shifting. Yeah.
I'm building on the Q&A in the chat right now. So if other people have questions, jump in. I was going to ask, there's a controversial question in the chat, which I think is interesting, which asks a question which I'll translate, but it's asking about, given, you mentioned this early on, Mark, that these patents, you know, things were filed 3, 4, 5 years ago, they come out now, life has moved on, the world's moved on. So is there a world where you might want to have differential fees for different technologies? Can't make term different, but you can certainly charge different fees. Is that a mechanism that officers need to think about?
Yeah, maybe, right? And so, I mean, you know, one thing we do in the United States, and maybe we could do more of, right, is sort of maintenance fees and sort of higher fees at the back end. Or you could have a substantial fee to file a lawsuit based on your patent, right? And so, you know, I think, because one of the things you might want to do is you actually might want to make it cheaper to get a patent up front for the sort of early stage first few years use. But if we think most of the harm is coming from people who kind of dug a patent out of the archives that was filed 15 years ago, we could make that a more expensive possibility.
Yeah. Another question in the chat, which is about both the High Court Australia and the US Supreme Court have recently declined to hear cases relating to CII cases. So does that indicate that at least the courts are comfortable that they know what they're doing, or are there things coming that we should worry about that's going to make this even more messy? No one has said AI yet. Barely said it so far.
Right. Well, so I'll defer to you on the Australian side. I mean, I think in the United States, right, there, you know, Beth said earlier, nobody likes uncertainty, and I think that's true right up until the point that when you get a certain outcome that is not what you're hoping for, and then a number of people say, hey, let's change the law. So I think a number of patent owners who are dissatisfied with Alice, right, have been trying for 10 years to persuade the court to change the law. I don't think it's going to happen. It's possible Congress will do something, but even that, if you've followed U.S. politics, you'll know how unlikely it is Congress will do anything, much less patent reform. So I think the Alice framework is in fact kind of here to stay for the foreseeable future, and you know, I wouldn't say it is a certain framework. I think it is a little bit of an I know it when I see it test. And that's challenging for some people, but I do think we're getting kind of guidelines that give us some rough sense of what's going to satisfy Alice and what's not. So there's things have settled down a fair bit.
I don't know if you have any thoughts on the Australian case, Beth?
No.
This sort of the question that's in the chat is getting a bit of a conversation. Is this link between, so if things happen in the US, do we just accept them in Australia? And does that matter? I think it's the actual question for the economists and lawyers in the room. Like, does it matter?
Yeah, the thing about these technologies is there's huge economies of scale, and they're insensitive to borders. They flow freely across borders. So if there's something affecting who owns or who can manufacture things in America, it's going to affect us clearly in terms of we buy and sell from them, or usually buy. So putting aside the legal issues, what happens in America does affect the world. I mean, the USPTO centers the de facto international patent office. So from an economic perspective, yes, I think it does matter. So manufacturers have told me, if you've got a technology that has such huge economies of scale, which sensors and chips clearly do have, you probably only need to patent in America, because if you knock out the American market, you're not going to go and set up a manufacturing facility in Australia. Where are you going to export to? I mean, you know, so America matters a lot when because it's, you know, it's still the biggest market in the world in terms of these industries with huge economies of scale.
Yeah, and I just want to because one of the things I think this makes really challenging, because it's hard to, you know, in the political conversations around sort of international patent systems, right, is I think it's easy to lose sight of the fact that Beth just identified, right, which is all of the patent rights are patent rights that anyone in the world can take advantage of for the same invention, right? So there's a kind of tendency, I think, among many politicians to think, oh, if country X strengthens its patent system, that means it's going to strengthen its local innovation compared to other countries. I think that's not true, or it's at least at best true only at the margins for really small companies, right? What it means is there will be a somewhat increase in the global incentive to innovate, but that increase is just as strong for a Chinese company that wants to file in Australia or the United States as it is for a US or an Australian company that wants to file in those countries, right? And so the kind of assumption that people often make that, right, how strong our local patent system is a function of will demonstrate or kind of direct how strong innovation is locally. I just think that there's a much more complex relationship than that.
Yeah, I'm conscious that we have a minute left. There's some great questions, some things in the chat which I think will add greatly to what IP Australia and Alphonse and Swin are working on the research. I'll bring one question together, the last two most upvoted things. Peter Franke, I think, makes a point you're making as well, Beth, that this stuff is everywhere, right? From toilets to satellites. So talking about a CI industry is like the odd thing, right? It's like electricity; it's used everywhere. And then Ron Wallace sort of compliments that, I think, was saying, so this allowability, is it having a different impact on startups in tech as well as SMEs with big companies? Does it lead to different things? Does it work on that? I thought I'd just clear that quickly.
Oh, well, I mean, that's an empirical question, isn't it? And I don't know the empirics on that. Basically, I don't know. Mark, you might know.
Yeah, I mean, I think it's got to be right that the sort of way the industries experience the patent system, and we know different industries experience the patent system differently, right? But I think it's also right, as Peter suggests, right, that you know, we're beyond the world where we can just talk about software as a discrete and unique thing, right? It's sort of you know, software is now your car. Right, and so we would have said 20 years ago, oh, the automotive industry has one set of incentives and interests, and the commercial software industry has a different set of incentives and interests, and it's very hard to distinguish those. But the flip side, I think, is also true, right? The sort of effects of software patenting, right, may be different in different industries, and we want to think about sort of whether we want or need to have sort of one rule or some more tailored and more specific doctrines.
Yeah. On that, I think it's incumbent on me to say thank you very much.
Yeah.
To Mark, to Beth, to everyone who came to listen. I'll hand over to Rebecca if you want to say anything.
I want to say thank you, Ben, on top of all of those already thanks. I knew you would conduct this symphony with a lot of panache, and so you have. Thanks, everyone. This has been just a really terrific conversation. And again, thank you to IP Australia for so generously supporting this kind of conversation for us to get these ideas out to a broader audience. We'll see you next time.
Thank you all.
Thank you.